Hi, everyone. Thank you for joining us. This is You, Me, and IP. I'm Justin McNaughton, and Sharon Urias is with me as well. We are intellectual property attorneys, and we've been doing this show for about a year, Sharon, or
A little over a year.
a little over a year. So this has been kind of a fun thing for us to do, and hopefully it's been useful to you all as well. A little bit about us. Again, I file and obtain intellectual property for people, and Sharon fights with people over intellectual property for clients. So that's kind of how we work together, and we work together quite a bit. This month was MJBiz was last month, and so it was last month. So MJBiz just finished up, and we thought we've had so many questions recently about intellectual property and cannabis that we thought we would just do this episode about that and answer some of the questions that we've received recently. So, but to kind of help make this discussion a little easier, as we go forward, we're going to just refer to anything with less than 0.3% Delta 9 as hemp, and everything that's running hot is cannabis. Otherwise it gets too complicated to try to talk about these things. So,
Justin, before we get into the questions, let's just sort of remind people what the intellectual property interests are that we're talking about real quick.
For sure. And as people have questions, just put them into the Q&A rather than the chat. If you put them in the Q&A at the end, we'll answer all the questions we can with the time that we have. So for sure. So Sharon, you want to run us through a couple of
sure. So the first one is trademarks. And what are trademarks? They are your brand. They're your source indicator. That's what's telling the consuming public who you are and what you sell through your logo, through your name, through your imaging that you display on your product packaging. And this is really intended to protect consumers so that they don't buy, Pepsi when they think they're buying Coke, or buy Adidas when they think they're buying Nike. The next class of intellectual property is trade secrets. These are proprietary, confidential information, processes, methods. This one's a little trickier, a little harder to define, but the bottom line is that you need to take reasonable measures to keep your trade secrets protected and secret, and they cannot be things that are generally known or ascertainable to the public. So Justin, why don't you tell everyone about patents and copyrights?
Yeah, so we got trademarks, trade secrets. Patents are a little bit different. Patents are a specific government grant that provides exclusivity or the right to stop other people from making, using, or selling something new and non-obvious. And it's typically a process or a design, some article of manufacture. So, and then copyrights are kind of a distant cousin, but copyrights are typically to protect creative works. It's the actual intellectual property that creates something that somebody has written, recorded, or made, but it's the actual artistic object itself. So that's kind of a quick summary, but the four are trademarks, trade secrets, patents, and copyrights. So as we go forward. So
right.
So Sharon, I'll ask you the one that we've gotten quite a bit.
Okay.
Which is, so people have asked, I've heard that the people are getting trademarks in the cannabis space. Is that true?
Well, so what I would say to that is yes and no. There's really no clear rule as to whether you can get trademarks relating to cannabis goods or services for that matter. I think that the best rule that we can state here is that if there's no federal statute that prohibits the sale of the product between states, then you can get a registration for a trademark in connection with those goods. So when you're talking about hemp, and again, back to Justin's definition, you can trademark certain hemp products. You cannot trademark ingestibles. So you can't trademark hemp gummies or vitamins, but you can trademark clothing or creams or topicals. That's fine. And those trademarks do get through the trademark office. But you also can trademark ancillary items to the product itself. So things that aren't directly associated with the plant. And I'm talking about things like rolling paper, lighters, ashtrays. It's a good idea to register your website. If you have a blog where you provide information about cannabis, about hemp, those are things that you can register. And so I think the bottom line is that it's important to register what you can in order to protect the overall brand. At some point, and we don't know when, so if you ask this in the question and answer, we don't have the answer to this one, as to when, if and when cannabis will be legalized federally. But you still can get some state trademark protection in states where, in most states where cannabis is legal. So as I said, can you get trademarks in the cannabis space? Yes, you can. Can you get it for, the plant that you're growing, your cannabis plant? Sorry, still can't do that.
And it gets kind of wild though, because you've got these strange rules where you can't get a trademark for like a gummy that has CBD in it, but you can get a trademark for essentially hemp cigarettes or hemp, pre-rolled hemp joints, right? Like, so that's a pretty odd distinction that's happening.
Line. Yeah, it
is. And it's kind of a gray area at this point as to whether just hemp oil, edible hemp oil by itself, that's an area where I think the trademark office has actually really struggled, and you see some things being refused and some not.
What about hemp tinctures?
Yeah, so you see different treatment by the trademark office on those, and so that is a difficult one to know, because in some ways it looks like it depends on which examiner you draw sometimes on those. So yeah, it's a difficult issue. For sure. So
another question that I got in particular at MJBizCon was, are there any restrictions on what I can patent for cannabis or cannabis related products?
So, and I think this question comes from, it's pretty common for people to mix up trademarks and patents. Mm-hmm. So we just talked about trademarks, and those are, the logos that brands carry. So patents are very different. And patents actually, they don't have a legality requirement. And so there's never actually been any sort of prohibition on obtaining patents in and around cannabis, which is really fascinating if you start thinking about it. But it makes sense. So you have to back up and think of the context of patents, though. Most people aren't probably aware of this, but there are lots of instances where somebody will get a patent on something, but they're not allowed to sell it. And think of every time that just a regular drug manufacturer comes up with a new drug or new something, right? They will be filing patents years and years before the FDA approves them to sell it. And that's fine. That's a normal thing to happen. That's part of the reason that these patents last for 20 years from filing. So patents, it's separate. Like, just because you have a patent doesn't mean you can go out and sell something. It just means you can stop other people from doing it, which in a really strange way is consistent with federal law on this. So
how do you enforce a patent if the invention, so let's say it's a cannabis strain, which I think we'll talk about later, but let's say you patent that. How do you enforce that patent in federal court?
So that's a good question. And that's where this is coming soon, I'm sure. Mm-hmm. But that is the real question, right? Is how do you, if you have a cannabis company and you have a patent, how do you walk into federal court and say, Your Honor, I want you to stop so-and-so from selling this product, when the first thing that company is going to, or the defendant is going to say is, well, wait a minute, this is, they're also an illegal company. They're also doing things that aren't permitted. And this court shouldn't look at any of this. And that's a big concern. So a couple things that we've kind of tossed around on that are, one, that and I guess to back up, so people are pursuing patents in this space, and there are a couple of reasons. One is life of patent, 20 years from filing. So that's a pretty long runway. So it may be that in the first years, it's difficult to enforce, but towards the end, if this industry is legalized federally, then those patents will already be in existence and they will become more and more valuable. So another thing to think about is, maybe putting patents in this area into a holding company. And this is kind of weird because in most industries now, people don't use holding companies because they were affectionately referred to as patent trolls, years ago, but apparently nobody really talks about patent trolls anymore. But in cannabis, it can be useful to put them in a holding company because then if somebody brings up this defense that like, oh, well, hey, they're also involved in illegal activities, a holding company doesn't. A holding company has no commercial activities. So sometimes that can be a useful way to do that. And then real quick, in cannabis, there are actually 3 types of patents that can apply. You've got utility patents, and these are what most people think of when you think of a patent is a utility patent. And a utility patent covers anything that it can cover any process or article of manufacturer. So if you come up with, it's usually equipment manufacturers, but it can also be your biotech people, right? If you are actually doing something to the plant or to the process, that can be eligible for a utility patent. But that doesn't really help. Utility patents probably don't help your average grower or dispensary because.
But aren't those the most common type of patent, Justin?
They are by far utility patents. And that's what people normally, when they think of, they think of a patent. But you've also got design patents, which can come up. And design patents they only cover what the actual article looks like. So these are more like consumer goods or, product. If somebody were to make an unusual shaped product, right? You can get a design patent for that. They're actually easier to get than utility patents. And that stops somebody from doing that same ornamental design. So it's a little weird because it's not like a utility patent. You're not protecting functionality. You're only protecting this fanciful design.
And what's interesting about that, Justin, is you could also potentially get a trademark for it, depending on whether the product is legal under federal law or not.
Right. But the way you do that is that typically you can start with a design patent because it's difficult to get a trademark on the shape of something.
Right.
But if you start with a design patent, sometimes you can use that as a way to keep people from adopting a similar shape. And then later you might be able to, convert it over to a trademark. So, and then the last kind of patent though is plant patents, and plant patents don't pop up in most industries, but they do in cannabis. But for the most part, they are not. Plant patents are, if you're a dispensary or an equipment manufacturer, or actually most growers, plant patents are not going to be terribly helpful. And the reason for that is they're really only helpful for people who are running nurseries, who are actually selling live plants. And the reason is that you can get a plant patent, but it protects a particular varietal, like a stable varietal. And the only thing it protects against is from other people asexually reproducing that. So basically cloning it. And since most farms are actually harvesting and selling dried product, a plant patent does not help at all in those industries. So it's a really interesting one. Not as much applicability though, as compared to the excitement about them in the industry. They actually don't have as much applicability when it gets right down to it. So the next another question we had, and I'll let you field this one because it's hard, is we get asked a lot, if I create a new strain, can I protect it?
Well, that's a very broad question, Justin. Let's start with trademark issues. So the question there would be, can you trademark the name that you give to your new strain? You come up with a great strain, you want to give it some really cool name. Now you want to know, can I trademark that and stop other people from using it? Well, if you think about it logically, why would you want to stop other people from using it? You want the strain to be sold, worldwide. You want it to become, I guess, famous. You want it to be profitable for yourself. So why are you going to try to stop other people from using the name? You'd really only want to stop other people from using the name if they were going to be coming up with some sort of, counterfeit or infringing product, right? And the problem that people have with this is that the USPTO does not allow you to trademark your strain name. Why? Because it's generic. It's the name of a plant. Whether you came up with the plant or not, it is generic and it cannot be registered with the Trademark Office. This is an interesting issue. It's one that's come up. It's one that we've litigated ourselves. And there's no clear ruling yet from a court on this particular issue in the cannabis field, although there have been rulings in other contexts. So as I said, in the USPTO, they've ruled that it's generic, descriptive, you cannot register it. In the context of other types of plants, and cannabis is, as we know, it's a plant. So to the extent that a strain is analogous to a varietal, which is a generic term for a particular type of plant, then it cannot be registered. And so, Justin, what about patent? I mean, can you patent a strain?
You can, and that's where, and although it's, for some reason in this industry, this word strain has come up, but usually these are varietals or cultivars is what they're actually called. In this industry, for whatever reason, people like to call them strains. And you can use a plant patent to protect a varietal, but again, it only prevents somebody from cloning that actual live plant. So it has to be asexual reproduction. So it doesn't help a lot of people. But the trademark issues are really interesting because essentially if you take a position that the name of your actual plant is something, then you can't come back later and say, oh, no, that's just a trademark for my brand. And that's kind of one of these issues that underlies all of this. So you have to be very careful that when you are referring to a trademark for your products, that you are referring to a trademark for the actual products you're selling and not to the name of the cultivar or the particular plant that you're growing.
And so the way to think about it, I think, Justin, is to think about it as your brand, not to think about it as your plant. So you're selling your plant under, this particular brand name, but that's not the name that you're assigning to the plant. So let's say you invent a strain and now you're filing a patent application. You would want to give it some other name in the patent application, right? Other than, say, Charlotte's Web, for example.
Right. And they've actually like created a mess for themselves because they, for years, called their products the actual cultivars, the actual strains. They called it Charlotte's Web. And then later they decided, well, gee, maybe we should turn this into a trademark. And that's very difficult to do because there's a lot of public policy reasons that you can't make that switch. And so you just have to be very careful to not refer to your plant, the actual plant, as whatever you're going to use for your trademarks for your products. So
that's right. And we're going to have a bunch of questions. So let's try to get through the next question a little bit quickly if we can. And that question is this: can the government go after me if I put something in my patent or trademark application saying that I sell cannabis products, which are still illegal under federal law? So in other words, is there going to be a referral from the USPTO to the government, to the US attorney, and I'm going to get arrested?
So, and that's an interesting one. So, and I guess my sort of answer is no more than just what you were doing already, right? Like, so if you're already selling cannabis plants, you're in the soup, right? But that being said, there are a couple of things to think about whenever you're making a filing with the US government. One is it should always be truthful. There, you don't ever want to make a false statement in a government filing, and that includes a trademark filing or any other. The other thing is that, so in this context, you need to think about, if you're going to file a trademark registration, if it's for something that isn't legal in interstate commerce, then I would not recommend filing a trademark for that thing that is not permitted. And the reason is that, well, one, it's not going to get allowed. The trademark office won't allow it. And two, now you've made a sworn statement that you are selling whatever that is to the U.S. Trademark Office, right? Which, theoretically, somebody could pick that up and use it elsewhere against you. Is that going to happen? I don't know, but we've certainly considered using it in a few lawsuits that we've been involved in. So we just want to be careful and always use, whatever you say needs to be true, and don't like needlessly submit declarations about things that you may or may not be doing in those filings. So, and we've got a bunch of questions.
We do. I mean, and I was just going to say, that's why you can't mess around with these filings. You really need to have an attorney who knows what he or she is doing with these types of applications. And I'll take the first question here. Okay. It sort of refers to something that I talked about earlier. The question is, aren't all cannabis intellectual property considered non-plant touching assets? Well, it's an interesting question, because intellectual property is an intangible asset. That is true. However, the problem is that to get a trademark, you need to be using the good or the service in commerce. And that means that it needs to be a lawful use in commerce. So that's why a trademark for let's say you try to get a trademark for your flower, because it's illegal to sell flower in commerce, cannabis flower in commerce, you cannot get a trademark for it. So when we say plant touching, that's really more just sort of colloquial for us, that we understand that the good or the service that we're talking about doesn't directly relate to something that is illegal under federal law because of the prohibition on the sale of cannabis.
So, and I'll take the next one here. So if cannabis intellectual property is considered non-plant touching, then is it subject to 280E taxation? And so this is actually a really, really complicated question. And we've certainly got some tax folks that can deal with that. But the short answer to this is, if there are ways to use intellectual property to generate income that shouldn't be subject to 280E. I mean, now the trick is actually you have to really, really set up a business that has nothing to do with cannabis. You have to sort of use your intellectual property in a way that it truly is a business licensing intellectual property, and not just a cannabis company that has some intellectual property. But this is the area that's sort of, really cutting edge in cannabis right now, is how do you do that? Because there's been at least one really big case that came down and said, yeah, no, what you're doing is not really a separate business. And so it is subject to 280 taxation. So that's all in the way you structure it. Sharon got another one here that says, earlier we said that ingestible products can't be trademarked. Why not?
Why don't you take that one, Justin?
You want me to take that one? Okay.
Sure.
And it's sort of, so some ingestible products can be trademarked. So of course, anything outside of cannabis that's permitted can be, right? But then inside of cannabis, you have to look and see if the ingestible product is actually permitted. And when I say permitted, you've got, you've got to look both at the DEA and the FDA. So if it's permitted, just because something is no longer on Schedule 1 does not mean that it's all of a sudden can be sold everywhere. And so there's a group of products that were deregulated from Schedule 1 on by the Farm Bill, but are still very much regulated by the FDA. And that's where if it's still banned by the Food, Drug, and Cosmetic Act, then it still can't be, you still can't get a trademark for it. So
No, I think the next two questions I can kind of take together, because it really goes to the heart of what constitutes intellectual property. And so one question is, can the Cannabis General Operating Agreement be considered an intellectual property? And can the Cannabis website be considered an intellectual property? And so an operating agreement itself is not intellectual property. It's not a trademark. It's likely not a trade secret, a patent, or a copyright. And so it's not something that falls under these particular, statutes, rules, and guidelines that we're talking about. The website, whether cannabis website can be considered intellectual property, is an interesting question, because what you're really asking is the content of the website protectable intellectual property? And it really depends on what's on the website. Are you displaying trademarks? Do you have copyrighted material on the website? If so, then what you're doing on the website is protectable. The domain name itself, if it incorporates a trademark, is protectable intellectual property as well. And there are classes in the USPTO when you're filing for a trademark application where they do cover services that are offered on a website. So for example, as I said, if you're offering educational information about cannabis, that's one particular class of goods or services. And that could be a blog, it could be a whole bunch of other information that you include on your website. So in that regard, yes, it could be considered intellectual property. Justin, is there another one that you can take here? I can't hear you.
oh, sorry about that. I'm not sure what happened. There's one left here. It says, would it be beneficial to patent a cannabis website, the cannabis recipes within a dispensary, and the general? Okay, we already talked about operating agreement. So
the recipes, that's
the recipes, you can't really trademark a recipe. A recipe, so a recipe is that's actually an interesting. Let's just talk about that for a minute. I know we'll go a couple minutes over, but I think it's okay. Yeah. So recipes are an interesting one where that is actually a really good example of trade secret. So usually the value of the recipe is that nobody knows what the recipe is. So you want to, and
like Coca-Cola, right?
Right, exactly. And like the fact that nobody's still really knows how to make it is what makes it valuable. And so the way that you protect cannabis recipes would be to make sure that nobody gets their hands on them. And that includes, I say that includes any employees who don't need to know that recipe to do their job. Any, just certainly nobody outside your company, but probably not even like friends outside your company that you just have some unexplained urge to tell. Like you have to be really careful with these things, because once a recipe's out, once a trade secret's out, it can't come back. And so you have to be careful with how you treat those.
Locked in a drawer.
And they can be very valuable though. So, well, I think, let's see, did we hit most of these? Did we hit most of these?
What should be done to apprise employees of the trade secret? Employment agreement, non-compete. There are a lot of things that you can do. You definitely want to have your employees sign confidentiality agreements. If somebody invents the recipe on behalf of the company, you may want to have an inventions agreement. These non-competes, we're not going to get into today. That's very complicated, and it's a state-by-state discussion. We're happy to talk to you about that offline. But the bottom line is you have to take reasonable measures to keep it secret, whether it's keeping it in a locked drawer, keeping it in a safe, need to know employees only, having access to that information, making sure that those employees are under confidentiality requirements. Those are the types of things that will help you maintain the secrecy and the trade secret status of your intellectual property.
And that's a great point. I think that's a good one to kind of finish on, which is, a lot of these things, just putting a password on a computer, right, or on a folder, or locking the cabinet, not telling everyone, like, there's a lot of value that goes out the door this way. And so you just have to be careful with those sorts of things. So, well, we really, really appreciate all of your time.
Yes, and we're sorry that we couldn't get to all of your questions. I see that there's another question relating to seeds. Please feel free to reach out to Justin and or myself, and we're happy to answer your questions. Our contact information is on the screen.
Thank you all.
Thank you.